that describes the permit areas, the subject permit areas, and then our draft administrative rule is actually going to go out on public notice October 1st. So this is the draft that's going to go out on public notice. Okay, so you should have 4 pieces of information. Okay, so let's first talk about the legislation. How many of you were involved at all in the legislative session? A few of you attended quite a few meetings. So here's, as you may know, that there were lots of bills related to suction dredging and motorized mining. This Senate Bill 838 is the one that passed, and it has been signed by the governor, so it's now law that goes into effect January 1st. So what does this legislation do?
It's all criminal. Yep, we're all made of
I'm sorry.
Yeah.
So, DSL did not have a position on this legislation. We were neutral. We are only responsible for implementing what the law is.
Which is illegal. Which is illegal.
Jack, right there. If that was implementing the law, it's obviously they have broken the law so viciously that they are criminals themselves because they did not adhere to the 1866 and 1872 laws, which overwhelmingly cleared what it is. And therefore, whenever we, as a group, went to Salem and talked to them about this, as you know, they had a plethora of bills that was before the group, and they kept changing. And there was a cease and desist even written on them, and they still followed through, even against the laws. These folks, and nowadays, how would be done? They themselves have broke the law so much until shame on them.
Well,
it is unbelievable.
So the legality of the statute is not something that I'm going to be able to address
And again,
or
people,
to
the
deal
judge
with.
himself made a determination on the law saying, hey, we've sent out a form of questionnaire to the folks saying, oh, are you recreational? Knowing that there's a play on words, and naturally 80% said yes. They made a full mistake because of their lightheartedness, and therefore it is a business on purpose because it's just
Yeah. Discussion.
So the legislation is what it is, and I'm so sorry that you're going to hear me say this over and over again. I can't do anything about the legislation from here. What I have to do is implement it. And in terms of the legislation and what it means and how it's interpreted, we are trying to interpret it with these rules. But you have recourse with your representatives, with your elected officials. There could be a change in the next legislative session. So that's your recourse. I cannot weigh in. I can't weigh in on the legality, but what I would like to do is inform you. That's my role today. I want to tell you what we think it means and what we're doing to address it, so that at least you'll have the information that you need. So that's my role. But, so I really can't talk about to whether or not this legislation is legal. No, I just, it's not my role.
It doesn't bother you that you could be held civilly or criminally liable for not stopping this? Because that's the reality.
It's legislation. We're doing what we have to do.
Did you guys take an oath of office when you become state employees?
No.
Good thing, huh?
Well, so we can talk about the information, and at least I want to give you the information. Okay, can we do that?
Sure.
Okay, good. All right, so what did this legislation do specifically? It imposed a moratorium on suction dredging and other forms of motorized mining on certain streams of Oregon starting January 1st, 2016. Between 2014 and 2016, it imposed certain restrictions on motorized mining. Okay, are you filming me?
Mm-hmm.
Okay, that's right.
Public meeting.
Smile. So the operating restrictions include a 500-foot distance between equipment, operating hours from 9 to 5, and a prohibition against leaving your equipment unattended in the water.
What about the permits? This authorization is only 850?
Yes.
And why is that?
So that's what the bill says. The Department of State
So
Lands
that
will
means-
limit the number of authorizations that we give to 850.
And what's the purpose of the permit to begin with? Is it for use of water?
This is for operation in the waterway below ordinary high
Is
water.
it for the use of the water?
It's to do any disturbance of any of the substrate below the bed and banks, the bed and banks of the waterway below ordinary high water. That's what the permit is for.
Again, Lori, right there on the permits, we have a right. It is not for us to give them a permit or ask for a permit. We have a right, and there is no set number. We have a right to go and do this, and that makes them again criminal.
There again, it's a granted right.
It's a granted right.
Yeah.
Please.
Not just permission, it's granted.
Yeah, I think the state of Oregon respectfully disagrees.
That's like saying the Constitution's not valid.
Okay, I got
Permit
another
is
question then.
required.
Okay, the water. It's not for the use of water?
No, we don't regulate the use of water.
Oh, yes, it is.
So you're actually regulating the use of the stream bed?
We regulate disturbance, it's called removal or fill, disturbance of the material, the stream bed material.
Why do we have to
Yeah.
take the machine out every night? My dredge weighs 600 pounds, and I was half a mile down the river from any takeout. That would cause me to have a heart attack. It's a health issue. You follow me? And I'm not going to take it out. You get these cops here to go get it. I'm not taking it out.
I would like to make one comment, and then I will be quiet. I'm going to read something to you. My name is Rick Barclay. I'm the Executive Chair of the Delisle Mining District. In PP&L versus Montana, and I'll make this as brief as I can, the state of Montana tried to extract money from PP&L. They went to court, went to the appeals court, went to the Ninth Circuit Court of Appeals. This ruling is from 2012. The rule for state riverbed title assumed federal constitutional significance under the Equal Footing Doctrine. Now bear with me. In 1842, the court decided that for the 13 original states, the people of each state, based on principles of sovereignty, hold the absolute right to all their navigable waters and the soils under them, subject only to rights surrendered and powers granted by the Constitution to the federal government. Martin versus Lacey of Waldell, 1842. In a series of 19th century cases, the court determined that the same principle applies to states later admitted to the Union because the states in the Union are co-equal sovereigns under the Constitution. There's various cases listed. These precedents are the basis for the equal footing doctrine under which a state's title to these lands was conferred not by Congress, but by the Constitution itself. Now, we need to listen to this carefully. In Oregon State Land Board versus Corvallis Sand and Gravel, and it follows that any ensuing question of navigability, and this is important, for the determining state riverbed title are governed by federal law. The title consequences of the equal footing doctrine can be stated in summary form. Upon statehood, the state gains title within its borders to the beds of water then navigable. Okay? And what that says is, although it is not, it may allocate and govern these lands according to the state law, subject only to the paramount powers of the United States to control such waters for the purpose of navigation in interstate and foreign commerce. And I'm almost done. And what that says is, this is the court's ruling, the United States maintains any title vested in it before statehood to any land beneath the waters then not navigable and not tidally influenced to be transferred or licensed if and as it chooses. Basically, the states have no jurisdiction on non-navigable waters, and as the chair of the Galeese Mining District, I want to go on record stating that the Galeese Mining District considers this an unlawful act and will not abide by it, nor will it tell its members to abide by it, and now I'm done.